The IBC is actually the first meaningful legislation in India to allow for turnaround and restructuring of distressed companies and resolution of bad debts. Historically, there were a number of legislations that banks had to take recourse against defaulting borrowers. All of these combined with RBI asset classification norms and provisioning norms, which were not stringent enough, led to a situation where a massive debt bubble came up. So it was in this backdrop of NPAs being built up that the Insolvency and Bankruptcy Code was enacted in 2016. The IBC prescribes a time-bound process of 270 days for insolvency resolution. Once a creditor files for insolvency, the NCLT is required to either admit or reject the petition. Once the NCLT admits the petition, the NCLT will also impose a moratorium against all the assets of over any litigation proceedings that the company is involved in and appoint an interim resolution professional. Upon its appointment, the insolvency resolution professional supersedes the board and takes over the operations and management of the company. The IRP will circulate a preliminary information memorandum, set out a public advertisement, collate claims from creditors, and constitute the committee of creditors. Once the committee of creditors has its first meeting, it will confirm the appointment of the IRP as the full-time resolution professional. The main role of the committee of creditors is to work towards an insolvency resolution plan for the company. A resolution plan needs to be sanctioned by the committee of creditors. The law actually does not prescribe what the contents of a resolution plan should be and can basically have any sort of financial or business restructuring proposal, from changing the capital structure to realigning the equity to raising new debt and financing, M&A transactions, or any sort of variation of those. If the committee of creditors is able to agree a resolution plan, then that plan is presented before the NCLT for approval. And if the NCLT approves the plan, then the company can come out of the insolvency resolution process with having to adopt the plan. If, however, there is no agreed resolution plan or the NCLT refuses to accept a resolution plan, then the company is required to go into compulsory liquidation under law. The IBC is a much needed law to provide for genuine restructuring and turnaround in India, but in the early phase, it's seen its challenges. But all said and done, the IBC is a step in the positive direction. It allows for companies to preserve their value and continue as a going concern. And most importantly, it provides an effective measure to address the NPA and distressed debt problem in the Indian banking system.